Greetings, my name is Patrick Phancao with the Asset Protection Center. I am an estate planning attorney focused in the field of asset protection and elder law out in the state of California and Florida. Today let's talk about the fundamentals of asset protection, its definition, and then I'll give you a few key pointers that you want to keep in mind irrespective of the instrument you want to undertake. So by definition, asset protection is simply the structuring of your assets, and think of the word assets as in your things, your stuff, home, bank accounts, stocks, retirement account, things of that sort, in such a way as to protect them from future potential risks, such as lawsuit. And notice I did say the word future because you do not want to undertake some type of asset protection planning if you're dealing with a past or a present litigation. So now that we have those in mind, let's talk about a few key pointers. Number one, the best form of asset protection is no asset protection at all. Now before you shut me off, give me a chance to explain what I mean by that last comment. So imagine an individual creates what is called a family limited partnership. And he does so for, number one, taking the particular asset out of his estate for tax purposes, and then he creates it for his beneficiaries, let's say his children, and does so because he wants to protect them from themselves in the event of a divorce or a lawsuit. So by creating this family limited partnership, he has created a valid estate plan which, as a tangential, causes a very solid asset protection structure around it. So that's what I mean by that comment. The best form of asset protection does not entail just asset protection. Another one is that there is a direct inverse correlation between the amount of control and the amount of protection that the asset protection instrument provides you. So the more control you have, the less protection it provides, and vice versa. And then finally, let me give you a few key factors that you want to keep in mind. Number one, the nature of the claim. Are we dealing with an individual that is coming after you for a potential threat, or are we dealing with a lawsuit that's been rendered as a form of judgment against you? Those are some factors you want to keep in mind. Then there is the identity of the debtor. If you're the one undertaking the asset protection, you are what would be considered a debtor. And when dealing with that, think about it as, have you been sued as an individual? Did you hit someone while driving? Or maybe you hit someone while in the course of a business, and therefore you are dealing with a corporation. So there are two different sets of laws with those different scenarios. Finally, there are the nature of the identity of the creditor. Are we dealing with an ex-spouse? Maybe a governmental agency. Maybe the litigating attorney is not so aggressive, or maybe he is. You want to take these factors into consideration. And finally, there is the nature of the asset itself. Are we dealing with a home, a cash, or retirement account? Each of these different assets, which there may be more, those are just the ones that come on top of mind, you would be using a different type of asset protection instrument according to the asset in nature. So that's it for today. If you have any more questions, please visit us at www.assetprotectioncenter.com, or if it's a pressing matter, feel free to call me at 714-966-2646, and I'll be happy to deal with your situation. Thank you, and I'll see you next time.